Welcome to the deep dive. Today our mission is, well, it's to really cut through the legal jargon around negligence. We want to show how courts figure out if someone messed up, breached their duty of care when, things go sideways unexpectedly. And we've got quite a story for this deep dive. It involves something totally routine, mowing the lawn, but it ends up in this huge garage fire, total loss. And it forces the court to look really, really closely at every single thing the guy did. So the picture is this. Robert Mathew, he's got this big riding lawnmower. It's heavy, and it's inside his brother's garage. He starts it up, boom, it catches fire, garage burns down. And the insurance company, Indiana Consolidated, they come after Mathew. They're saying he was negligent, not just once, but 3 different ways.
Yeah, and what's really, really critical for you to take away here is that we can't just look at the end result, the burned down garage, and jump to negligence. That's not how it works. We have to use specific legal tools. So we're going to break down Mathew's actions using really 3 main ideas. First, the standard of the reasonable prudent person. Second, this concept of foreseeability, which is huge in breach cases. And third, how the sudden emergency doctrine comes into play as a defense when he reacted to the actual fire. And we're not just giving you the highlights. We're actually going to model how the law applies step by step, element by element, to the facts. It's this framework, the structured way of thinking that really shows you why Mathew won.
Okay, sounds like a detailed breakdown. So before we even get to the flames, what's the basic rule? What's the fundamental yardstick the court uses to measure Mathew's conduct overall?
Right. The black letter rule, the foundation, is whether he used the care that an ordinary prudent person would exercise under the same or similar circumstances. That's the standard. And Indiana Consolidated, the insurance company, they basically threw 3 things at him. They said he breached this duty, first, when he was fueling the mower, second, when he actually started inside the garage, and third, when he didn't push the burning mower out once the fire got going.
Okay, let's tackle that first claim then, the fueling. Indiana Consolidated said he must have spilled gas. They pointed out that on cross-examination, he admitted he could have spilled some. But Mathew's story was different, right? He said he used a funnel, didn't fill it all the way, and besides, it was cool out, he was gone for 20 minutes. Any spilled gas probably would just evaporated. Yeah. So how did the court deal with that? Where the insurance company basically wanted the appeals court to second-guess the trial judge about whether Mathew spilled gas or not.
Well, this is actually a really important point about how our court system is set up. The trier of fact, that's the person or jury who decides what actually happened. In this case, it was a bench trial, so it was the trial judge himself. He decided the facts. And he believed Mathew. He found that Mathew did exercise due care when he was fueling the mower. Now, because Mathew won at the trial level, it's called a negative judgment against the insurance company. The appellate court, the higher court, they can't just jump in and say, we think the judge got the facts wrong. They don't reweigh the evidence or decide who was more believable. Their job is mostly to look for legal errors. Since there was evidence supporting the trial judge's finding, Mathew's testimony, that finding has to stick. So claim number 1, it fails right there because of how appeals work.
Okay, that makes sense. The appeals court isn't there to retry the case based on the same evidence. So moving on to the really central part, the second claim. The insurance company argued Mathew was negligent just for starting this mower. It was an 8-year-old Toro, pretty big, riding type, inside his brother's garage. I mean, to a lot of people, starting an engine that then bursts into flames inside a building, that sounds risky on its face. How did the court approach that? Let's analyze Indiana Consolidated Insurance Company v. Mathew concerning the act of starting the mower. So first, what are the legally dispositive facts here? What exactly happened when he started it?
Okay, the key facts are he pulled this large riding mower away from the wall into an open space in the garage. He gave it room. And critically, the court pointed out that, well, garages are normally used for starting things with motors, like cars. That's kind of what they're for.
Right. And what was the core legal issue for this specific claim? What question was the court trying to answer?
The issue is really about foreseeability. Would a reasonably prudent person expect that starting this specific mower, which seemed fine, it wasn't obviously broken in an open part of the garage, would suddenly cause it to catch fire? Was that particular risk foreseeable enough to make starting it there negligent?
Okay. And what rule of law did the court use to figure that out? Can you state the full rule and break down its testable parts?
Sure. The standard is, again, that ordinary prudent person under the circumstances, but how do you apply that? It hinges on foreseeability. The court explicitly said, and this is key, one is not required to anticipate that which is unlikely to happen. So the rule for breach here really has two parts, two elements you need to check. First, did Matthew's action itself, starting the mower in the garage, fall below what a reasonable person would do? And second, was the type of harm that resulted, the fire, reasonably foreseeable?
Got it. Thank you. Now let's get into the court's elemental analysis, step by step. How did the court apply that first element, the idea of the ordinary prudent man standard, just to the act of starting the mower itself?
Well, the court did a sort of mini analysis there. They looked at it and said, okay, it's a big riding mower, kind of like a small vehicle, and people start vehicles in garages all the time. He pulled it into an open area. So the act itself, starting a machine that seemed okay in a space designed for vehicles, the court found that wasn't unreasonable. It didn't deviate from what an ordinary prudent person might do.
Understood. So the act itself gets a pass. Now, what about the crucial second element, the reasonable foreseeability of the fire?
And this is exactly where the insurance company's second claim falls apart. The court looked squarely at this and decided that the specific harm that this mower at this moment would just spontaneously catch fire was not reasonably foreseeable. There was no sign it was about to happen, no leaks, no sputtering, nothing beforehand. And because that specific event, the fire, was considered unlikely to happen, Mathew wasn't legally required to anticipate it. If you couldn't reasonably foresee the harm, you haven't breached your duty to prevent it.
Okay, so if we're looking at both the reasonableness of the action and the foreseeability of the harm, what was the court's final conclusion on this negligent starting claim?
They upheld the trial court's decision. Mathew was not negligent in starting the mower. Why? Because starting it was reasonable conduct, and the fire that resulted wasn't a foreseeable risk under the circumstances.
Which brings us to the third and maybe the most dramatic part of the case, the final claim. Negligence for not acting after the fire started. The insurer said Mathew should have pushed the burning mower out of the garage. But the facts, wow, they paint a scary picture. The machine starts spewing gasoline, and Mathew testified he was genuinely scared. Scared the tank would just explode right in his face if he tried to push this heavy 10-foot machine. So he ran to call 911 instead. Let's apply that same rigorous analysis here. First, lay out the legally critical facts about what Mathew did after the fire breakout.
Okay, so the fire starts small. Mathew actually tries to smother it with towels, but it gets out of control fast. Then, the key facts. The mower starts spewing gasoline. This creates an immediate, serious danger, an explosion risk. Mathew, facing this, decides his priority is getting help calling the fire department rather than trying to wrestle this heavy, flaming, fuel-spewing machine out, which meant putting himself right in the line of fire, literally.
And the core legal issue for this final part.
The issue here is whether Mathew's choice, his failure to push the mower out, choosing self-preservation over saving the garage, counts as negligence, especially when you consider the sudden emergency doctrine.
Right. So what rule did the court apply to judge his reaction in that moment of crisis? Can you state the rule and break down its elements again?
Absolutely. They applied the sudden emergency doctrine. The rule basically says, if you're suddenly faced with an emergency that you didn't create yourself, you won't be held negligent if you act according to your best judgment at that moment, provided that's what an ordinary, prudent person would likely do in the same chaotic situation. And this doctrine has three distinct elements to test. First, was there actually a sudden emergency? Second, was the emergency not of the actor's own making? And third, did the actor's response measure up to ordinary prudence under those specific emergency circumstances, essentially? Did they use their best judgment given the panic and danger?
Okay, let's take the first and second elements together. Was Mathew facing a sudden emergency? And was it something he caused himself, legally speaking?
Yes, clearly. A sudden fire, gasoline spewing everywhere, that's definitely a sudden emergency. And critically, because the court already decided he wasn't negligent in starting the mower in the first place, this emergency was legally considered not of his own making. So check and check. The first two elements are met.
All right, now for the element that really carries the weight here, the third element. Did his reaction running for help, instead of fighting the fire himself, meet the standard of ordinary prudence in that emergency? This is where that whole life versus property idea comes in, isn't it?
Exactly. And the court found his response was prudent. They really leaned into this element to make a strong policy statement. They emphasized that the law values human life and safety more than it values property, period. Mathew is staring down the barrel of potentially a catastrophic explosion, grave injury, maybe even death. That risk is infinitely worse than the loss of a garage, which is just property damage. So his decision to back off, call the professionals, rather than risk getting blown up to save a building. The court saw that as the definition of ordinary prudence in that moment. They even pointed out that in some places, if you do recklessly risk your life just to save property, that itself could be considered negligent.
Wow. So, after analyzing all three elements of the sudden emergency doctrine, what was the court's final conclusion on Matthew's actions after the fire started?
The conclusion was clear. They affirmed the trial court again. Matthew's decision was prudent. The law doesn't require someone to be a hero and risk severe harm or death just to save property, especially when faced with an immediate, terrifying threat like an exploding gas tank. He acted reasonably under the emergency circumstances.
That policy point life over property, it really is the core takeaway from that part of the case, isn't it? To really hammer that home, let's try a hypothetical. Imagine Matthew had a cat, let's say his favorite cat, sleeping maybe 10 feet from the burning mower. Suppose he quickly grabbed the cat, tossed it safely outside, but still left the mower to burn down the garage. Would that change things? He saved a life, sort of, but not a human one. Does the policy still protect him?
That's a really interesting question. The court's language does specifically mention human life, but the underlying principle, I think, is about the proportionality of risk versus reward. Why was Matthew excused? Because risking a potential explosion just to save property, the garage structure, was deemed unreasonable. Now, if he took a brief, arguably lower risk to save a beloved pet, well, that complicates it slightly. Saving the cat might be seen as understandable, maybe even reasonable, depending on the exact risk involved in that specific action. But the core holding of the Mathew case still shields him from liability for the main damage, the loss of the garage itself. The law recognizes that severe bodily harm or death from an explosion is an irreparable loss. Property, like the garage, is ultimately replaceable, usually through insurance or money. So even with the cat scenario, the court's reasoning strongly supports his decision not to tackle the exploding mower itself. His primary duty isn't to sacrifice himself for the building, regardless of pests inside.
Okay, that clarifies the strength of that policy. We've really taken this case apart, piece by piece, element by element, showing how the court used these different rules for foreseeability, sudden emergency, to reach its conclusion. So, pulling it all together, what does this deep dive give you, the listener, as a practical tool? How can you use this structured thinking for analyzing negligence problems yourself?
Right. This case actually lays out a fantastic diagnostic checklist for tackling the breach of duty element in negligence. When you're faced with a scenario, you can ask these 5 questions in order. First, identify the standard. Always start there. What would the reasonable, prudent person do under these exact circumstances? Second, evaluate the conduct itself. Was the action inherently risky? Or was it pretty typical, like starting a seemingly fine machine in a placement for machines? Third, test for foreseeability. This is often the make or break question. Was a specific harm that actually happened something that was reasonably likely to occur? If it was way out there, unlikely to happen, then a reasonable person wouldn't have had to guard against it. That might defeat breach right there, like with the fire starting in Matthew's case. Fourth, check for sudden emergency if it applies. If the alleged negligence is about how someone reacted to a danger or failed to act, run through the 3 elements. A, was there a real emergency? B, did the person cause it themselves? C, was their response reasonable for that crisis moment? And fifth, apply the life versus property policy. If that emergency response involved a choice between personal safety and saving property, always bring in that strong legal policy. You can take more risks to save a life than you're expected to take just to save stuff.
Perfect. So this deep dive really underscores that you can't just look at the outcome, like the garden garage, and work backwards. You absolutely have to analyze the foreseeability of each specific action before the harm happened, and then consider the powerful policy reasons, like valuing safety over property, when judging someone's reaction during a crisis.
Exactly. And it leaves us with a final thought for you to chew on. What if Matthew hadn't been just an ordinary guy? What if he was, say, an off-duty firefighter, someone with professional training in dealing with fires? Would the ordinary prudent person's standard morph into something higher, reflecting his skills? Or would that fundamental policy that you don't have to risk getting blown up to save property still win out, regardless of his training? That's definitely something interesting to consider further.